that's okay for right now. We'll have some more questions coming in right now too. We can get to the end of it. So we can go ahead and get you started though on this evening's presentation on the wills and power of attorney. So Keith, we are greatly appreciative to have you again this evening, and I will just turn it over to you to start tonight's presentation, and then we'll answer or ask the questions of you at the end, okay?
I don't know about the rest of the counties, but here the crowd is doubled in size. So I must have been saying some good things the first time. I had a Baptist minister in the crowd one time, and I talked for 2.5 hours, and we had an hour and a half of questions, and the extension agent says, y'all got to go home. He's got to drive 3 hours home. This 85-year-old man came up to me. He said, son, he said, I've seen it all. He said, I'm 85 years old. I've been a Baptist minister for 60 years. He said, not a one of these old men fell asleep. None of the women fell asleep. The men didn't go to the restroom. I wouldn't have believed it if I hadn't seen it. He said, most ministers are lucky to hold them for 15, 20 minutes. He said, so obviously you might be pretty good, but definitely everybody's more afraid of death and taxes than they are of hell. So I think that made me feel pretty good. And at least I thought maybe they wanted to come back. But the good thing is, hopefully, the whole thing we're trying to do in this series, and I'm working with Extension always, it's about education. It's hopefully that you can learn something that you can help when somebody at church or at a cattleman meeting that has an issue. You might not know the exact answer, but you can say, hey, I know this is important. You need to get this checked into because it's important. So, we need all of you to spread the word to your friends and neighbors when something does come up, is that, you've learned something through Extension that can really help beyond the room and that we're dealing with, all the rooms we're dealing with tonight. Okay, so what we're going to get on is back to my practice is really bizarre. I'm limited to agricultural law because we can't specialize in Kentucky unless you're on TV. I know you get the Hammer and Morgan and those. If size matters, I'm 6 foot by 260 pounds. So size matters, Morgan and Morgan. I'm bigger than some of the lawyers around. But almost all my clients are farmers, and farming is it's gotten to be a different area because most, even the rural lawyers, they used to do a lot of clients that had farms. Well, they had farms, or their grandfathers had farms. Well, now it's their great grandfathers had farms. Or the same way with the accountants or CPAs. So when you're dealing with a specialized business, because in the Depression, they realized that obviously farmers will farm to the point of starvation or bankruptcy because it's an addiction. I've got 3 sisters. They did not become addicted. I guess I chewed on my fingernails more than they did, but several of my cousins are addicted. And we're proud of it, but the specialization that the government realized that, well, if we can keep these farmers just above starvation or bankruptcy, they'll keep farming. We'll have cheap food for now 99% of the rest of the country. So we have special rules for income taxes, property taxes that the other people don't get. Oh, back to that first question, the property taxes. The property taxes on your land, it's not based, it's based on ag value. So you could have a farm that's fair cash value worth $15,000 an acre, but its ag value, it may be $1,000. You'll be taxed on the 1,000. Now your house, the taxes again is not ag value on that property around the house, so that could go up. But generally, it's not going to affect your taxes for property taxes. I didn't get that part of the question. Well, let's see if we'll get. I'll move pretty fast, and then we can always come back for questions. So do I have to turn it on? A little clicker is this one, correct? we're getting our technology here. There we go. Okay, so we talked about on the first session taxes, but we also talked about the complete farm estate plan involves disability, business plan, and the estate plan. It's not just a will. Getting a will can help, but it's not near an estate plan. I don't write wills. I do estate plans. And then tonight we're going to hit on a bunch of the estate planning parts with deal with disability. And actually, at death, it's a little easier because the statutes say how things work. But what's critically important is between now and the day you die, if you're in a car wreck and you're unconscious, you're disabled, and it may be temporary, but you've got papers that need to be signed at the bank, or tax returns that need to be signed, or there's a sale pending or a purchase pending. If you don't have a power of attorney document that you've signed attorney in fact to take your place, what are you gonna do? You might blow a really good deal for your farm or a sale for your farm. So also just dealing with the hospital, living wills, healthcare power of attorneys are fine for your healthcare part, but I guarantee you the bookkeeping part of the hospital wants to see a financial power of attorney. Who's going to pay? Who has the power to deal with the insurance company? That's what they want to see. So just like the estate plan we talked about, it's more than just a will. And now you may have a will, you may not. You have a trust or survivorship or other things we'll talk about. But the disability part, whether you're 18 or 98, everybody needs to have an estate plan that includes a living will, a healthcare power of attorney, and a financial power of attorney. That's my usual graduation gift to my friends' kids, and my nieces and nephews. Is they get out of high school, they get to have an estate plan. And people say, well, why do that kid doesn't need an estate plan? He doesn't own anything. Yeah, but he gets hit by a semi and there's a $3 million settlement. How many people in the family are going to line up to fight for it? And who's going to deal with the lawyers to help get the money? Pretty important. Also, once you turn 18, mom and daddy can answer for the child. What if mom and daddy are divorced and they're not 18 yet? Now what? Well, what if once they turn 18, doesn't matter if they're divorced or not, they can't answer for the child because she's now 18. So you would have to go do a guardianship hearing. We're going to deal with that. And that's a mess you don't want to have to deal with unless you have to. But there's disability planning, the estate planning, which is planning for your death and how things be done. We talked about tax planning in the first session, the family farm planning. We've talked a little bit then. Clint talked a little bit about it, I'm pretty sure. And we're going to hit it a lot more in the next session about the family farm planning. So disability planning, you've got healthcare decisions again, that who's going to make them? Mommy or daddy could make them until they're 18. After that, they can't. Brothers and sisters can't make them for each other, for a disabled brother that's 60. And if he's been making his own decisions, but now he can't, or he's been in a car wreck, or he's in drug problems or alcohol problems or whatever, that he can't make that healthcare decision, you're going to have to do something. The financial decisions, again, these are legal documents that you better have some documentation, or you're in for a pile of headaches and long calls on the phone that aren't going to get you anywhere because they're going to say, send me the documents, and you don't have it. So the other thing is going to be, is that evolved into a long-term care situation, either at home or in the nursing home? And this could be an 18-year-old that's in a car wreck. It could be a 98-year-old that's still alive and going, but it's got to have help. That one we're going to get along to next fall in the latter part of the series is the nursing home and deal with Medicaid, long-term care insurance, and those things. If we try to do all of it, we'd be here for 2 days and not go home. So the healthcare decisions is you always, if you're competent and over 18, you can always make your own decisions. But again, what if you can't? what if you're unconscious in the wreck? My niece, example, she was volunteering. She was 19. She was going to community college in Shelbyville. She was volunteering at the middle school library. And she was up on a tall stool at the checking or doing the checkout stuff. And somehow she passed out or something and fell off this tall stool and basically broke 2 vertebrae in her neck, fractured 2 vertebrae in her neck. Luckily didn't completely paralyze her, but she never lost consciousness. So my sister, after that was over, she realized because she asked herself, how come they never asked for any documentation? I said, well, because she was conscious. So if she had ever gone unconscious, what was my sister going to do? Nothing. It would be all under the control of the hospital, the doctors and nurses, and she would have to go get a guardianship hearing that could take 3 to 6 months to get done. Your guardian is that guardianship hearing. It's a competency hearing. It's a probate process in district court where there's a jury trial to see if somebody is competent. And if you've ever had to do that, it's horrible. I had to do that for my grandfather, and here you are up having to testify that one of the most important people in your life is incompetent. And to do it, you go to the county attorney's office, county attorney takes your petition, you have to be a related party, and interested, preferably related to party to the person that's disabled. Then they go to court and the judge appoints a lawyer to represent the disabled person, a medical doctor, a psychologist, and a social worker. Social worker evaluates their home or living situation and family. The psychologist, the mental situation, and the doctors, the health, physical situation, and the lawyer, the legal situation. Now, how long do you think it takes to round up a written opinion from each of those people? It could take 3 to 6 months. Then you go to court and have a hearing, or actually a trial with a jury of 6 people. And the county attorney represents the person that is the petitioner and the person asking to be appointed. And then the attorney that's appointed for this disabled person, they represent them. And it's just like a trial. They question those witnesses. The person that's signed the petition has to get on the stand and testify as to what's going on. You may have other people. Sometimes you'll have family members fighting over who's going to be appointed. I mean, it can get ugly, but the main thing is just tough to do when you're saying, again, an important person in your life, your spouse, your child, your parent is incompetent. And then once you get it, you've got to deal with how do we make that work? To sell land, you as a guardian, you have to go to court and ask to be able to sell land. That can add 3 months to the sale process. And if Medicaid is saying, we've got to sell that property, what are you going to do? If you need to sell it to provide finances, what are you going to do? It complicates the delay. The other part of the guardianship is there's a full guardianship, which is health care and financial decision making. You can be a conservator, which is just for the finances. There's times that the judges has appointed me as the public administrator for Henry Oldham or Trimble County in our district. They would appoint me as a third party. I'd handle the money because mom and daddy are divorced and they're fighting over the money that the kid got in a car wreck. And he doesn't want her to have it, and she'll spend it, and she doesn't want him to have it because his girlfriend will spend it. So I get to have the money. And I pay for appropriate things and make reportings to the court. Or sometimes parents will or children will get appointed as guardians and they don't make an annual reporting. And you have to report back to that judge annually to say the person's still alive, here's how their health is, here's how their finances are, here's the situation. we still need this guardianship. But a lot of times people won't do that, and then the judge would strip them of the guardianship and they'd appoint me as a public administrator, which is typically a lawyer in the community that would do that. Again, you're fighting and feuding amongst the family, but if that child had been 18, if they had been 18 and had a power of attorney, you eliminate all that. So a good divorce lawyer will always immediately send you to a good estate planning lawyer. So if you know nobody getting divorced, ask them, what are you going to do with you got a will? You got divorced now, but do you have a will? Pretty important. If any of y'all lived through that with a parent or a spouse or child, you understand. Now, we've got the healthcare power of attorney and the living will. Now, the power of attorney for healthcare, we talked about guardians, power of attorney for healthcare, this eliminates the need to report to the court. We don't have that reporting to the court obligation. It's between the person that grants the power and the person that's appointed. So what is it? Well, a lot of people don't have a healthcare power of attorney because they're only been around about 10 years, which is a short time for us older people who've been starting to quote when things happened 40 to 50 years ago. But a lot of people don't have them. They've got a one-page power of attorney or half-page power of attorney that their neighbor lawyer wrote when they got married 35, 40, 50 years ago. The power of attorney for healthcare, again, it was driven mainly by hospitals and national nursing or insurance companies, health insurance companies. They wanted somebody that was legally appointed in the document to answer these questions and make these decisions. Well, when I started 30 years ago, it was a power of attorney was a half page long, and it said one line about healthcare or one phrase. Well, that phrase is now a 6-page document because those insurance companies and hospitals, they want everything possibly you can do. Now, the healthcare power of attorney is, again, a difference of a living will or a guardianship is you don't report to the court like the guardian, and the living will is if you're terminal. A healthcare power of attorney is if you're just not able to deal with that insurance company because you're at home and you feel horrible and your spouse or whoever you appointed can deal with that 3-hour-long wait to talk to the insurance company. So it could be a day-to-day thing, picking up prescriptions at the pharmacy. Sometimes we still get away with it in rural areas, but the local pharmacist that my mom went to, my mom had that girl's parents as kids in the church youth group. Well, I went in with my mom and gave the pharmacist her healthcare power of attorney that named me, but she'd known me all her life too. But she was really relieved that she could put that in the file. But also, I had my 3 sisters, 1, 2, 3, 4 listed. And if anybody on that healthcare power of attorney went to the pharmacy, they could pick up the prescription because they had legally been appointed. Now, they're not a decision maker. You're your own decision maker if you can. If you can't, it's the next person or then the next one. But you have to, if I'm first, my sister that was second, she couldn't make major decisions like pulling or changing doctors, making care decisions without proof that I was either resigned or I was dead. Because she was part of the committee, an advisory committee that could ask the doctor questions, could call and make appointments or change appointments, but she couldn't make decisions because my mother was still competent. But it keeps the legalities of those offices under control, but also again in divorce situations, those spouses or parents or ex or whatever, that 18-year-old might not name his biological father or mother. You might name even his stepfather or mother or his grandparents, but that's who then would have the power. So that's what it does. And you get one, the best way to get a good healthcare power of attorney is from a lawyer that understands your situation, that talks through with those issues that fits your family situation. Because lots of family situations are different. Little bitty details can change. Just driving down the road, so-and-so might be seem like they're just like you, but they've got a little bitty detail that's legally major difference in your planning. Where do you keep it? The power of attorney for healthcare is not recorded anywhere. You need to keep the original in a fireproof box, a safe, a safety deposit box. Because if that person's disabled, they can't make another one. Now, most of the places that you're dealing with will use a copy of a copy. Now, some of the insurance companies and occasionally a hospital will ask for an affidavit where the person that's being named, which is the attorney in fact, the power of attorney is a document. The person named or granted the power is the attorney in fact. They may have to sign an affidavit that's notarized swearing that this person is disabled or unable to deal with this insurance company at the time, and that this is the most current document, that no other documents have been done, and this one's never been destroyed. But you have to sign that affidavit, and that's on the occasion of a national insurance company. Most of the pharmacies, doctors' offices, they don't worry about that too much. I haven't had that much of an issue with them. Can you change it? Yes, you can change it. If you're competent, you can always change it. And that's another thing that people do is that sometimes there's somebody that needs to get moved down or taken off, somebody else put on. A lot of times I have a client that the husband's died and he was named first. The second was the daughter, and she lives in Texas. But the surviving spouse's sister lives next door and she drives, the other one doesn't. So the driver, and to take her to the doctor, the hospital, the grocery store, the pharmacy is the sister. We need to update it and put the sister on there somewhere in the list and take the deceased husband off. Otherwise, you'd have to carry a death certificate with you to prove that he's not able to function in that role. So you can always change it, update it, as long as you're competent. On a living will, we're going to get into that a whole lot as the end of life issues at the last session. But I wanted to bring it up today because it's important because it goes along with this package of documents. If I do somebody's will, almost always they're going to get a power of attorney, healthcare, financial, and a living will, unless they can show me one that they have that they really like and it fits the situation. A lot of times they get it and go, "Oh my, I need to fix this. I forgot this happened." But the living will is two doctors. It's controlled by statute. It is also a document that grants power to someone else. And it's you always make your own decisions. If two doctors say you're terminal, you're going to die sooner than later. Legally, the statute doesn't spell out so many days or anything like that, but you've got something that's going to kill you sooner or later. Sooner than later. Let me rephrase that. If you've named someone that's surrogate, they're not the attorney in fact, they're the healthcare surrogate. They have the ability, you can make it, you do a check, there's 4 different options, and you could say from one end of the spectrum, keep me alive no matter what, give me everything you got. If my heart stops, bring me back. Could die again tomorrow, but bring me back then too. I've had one person in 30 years do that. About a month later, the Terry Chabot case out in Missouri, a few years with the judge, the governor, and courts were fighting. She came back to my office. She said, "Is that going to happen to me?" And I said, "Well, no, they're going to keep you alive no matter what." She goes, "Oh my gosh." So it really amounts to half the people will say, let the surrogate decide. Other half the people say, no, if I'm terminal and I cannot make a decision, I'm unable to do that. Give me pain relief. don't do any life prolonging measures. If I started any life prolonging measures, my surrogate has the power to withdraw. Because you may start a treatment and it doesn't work. That if I don't want a feeding tube, but if I have started one, they can pull it. And if my heart stops, don't bring me back. So you have this spectrum of range from keep me alive no matter what to let me go, don't bring me back. Half the people will do let them decide. Half of them here. Had one 90-year-old lady barely could see above my desk. She said, that one right there, that D, let them decide. She goes, that's a weenie's way out. She said, I ain't letting nobody decide for me. But I used to think it was an age thing. It's not. I found over the years, it doesn't matter. I've had 18-year-olds say, no, let me go, don't bring me back, because they lived through a grandparent situation. It's a mixed bag. Sometimes spouses do the same. Sometimes they do the other one. Sometimes they do different. And the main thing is it's up to you. And the real issue becomes, like my three sisters, two of them, I don't want making any healthcare decisions for me. One of them, maybe the other, yeah, they'd be all right. But the one sister, you just mention the hospital and she starts crying. So you don't want her in there to make a decision. In the same way with finances, we're going to get to, just because you name one person here doesn't mean you have to name over here. The good healthcare person may be horrible with numbers. So you got to look at each document itself. The living will, you can always change it. You can always, you don't record it anywhere either. You copies of copies, and we keep a copy of any of them that we do. And a couple of times a year, we'll get a call from the hospital, and they'll go, we ran off without mom's living will. Can we come get it? And I said, no, go to the nurse's desk and get their email address. And before you're in the parking lot, we can go to the file, pull it out, scan it, and email it. Or it may already be scanned in. Used to be fax, but we don't do that anymore. But having, if you appoint, when we do a plan, you'll get a binder, we do a binder, and you have copies in the binder of all these documents. And then we also give you about the originals that goes in a fireproof box, safe deposit box. We give you 6 or 8 copies of the living will of the healthcare power of attorney. Give those to the people you name, the pharmacy, your doctors. Some people need 10 copies. Some people don't have doctors because they have been in 10 years. But at least give them to the kids. The other thing we do with the living will and the healthcare power of attorney, put them in an envelope, a copy. Put living will, POA healthcare on it, and put it in your glove compartment. Because when you're in the truck wreck, the EMT will look there. And your living will, we put all their addresses and phone numbers, which is extra. The statute doesn't require it. But I have a lot of friends that are EMTs that just have loved that. Because they pull that out, this person's laying there unconscious, but they got all the cell phone numbers of the people that need to know. So have that in your glove compartment. You can carry it in your purse. Another question always is, does it work if I'm out of state? Yes. Most all the states have a centralized, uniform statute that your Kentucky living will work if you're in Florida. Now, if you go out of the country, probably most countries. But you go out of state, anywhere in the United States, your living will work. And so you can just have it with you if you can. But do put one in your copy in your truck or your car. Is that, then you don't ever have to worry about it again. It's in there. Like I say, put big letters on it, put it on top of your owner's manual or whatever else you've got in there. Change it when you need to. Pull everything out. I tell people to look at it, think about it every year or 2 or 3. Don't review it on your birthday. That's not a good idea. But don't do it on New Year's Eve. You might be celebrating too much and get depressed. But Groundhog's Day or something, pull all of it out. Take a look at it and see if there's something happened. I've had a lot of times people call my office and I can think, they'll say, I heard you talk at extension meeting 8 years ago. And I can think right then, well, somebody there has just come home from the hospital, the nursing home, or the funeral home. And they're thinking about it, and it's rising on their priority list. But do try to keep a day there somewhere in the year. Most lawyers try to send out letters every couple of years to remind people to look at it. Major life changes, especially with health or family members. You know, maybe the son-in-law is now in good graces and they can be named, or the daughter-in-law, or one of your kids your in-laws have turned into outlaws, like we talked about the first time. The financial power of attorney, we have to have financial decisions. Well, you can always make your own if you're competent, like I said, just like the rest of it. If you're not, you gotta have a guardian. If you don't have, hopefully, you won't have to do the guardianship if you've got a power of attorney. Again, one thing you want to learn, if you want to amaze your friends and embarrass your family and talk like a lawyer, but every time somebody asks you a question, we did this first meeting, you always answer with, well, it depends. No matter what the question is, well, it depends. But the other thing you can do is people think, I'm the power of attorney. No, you're not. The document is the power of attorney. You're the attorney in fact. And the bank, when you sign checks using that, you should put attorney in fact, or ATTY-IN-FACT, not POA. So it depends on the teller and what they know. But just a little educational notice there. Again, you can embarrass your family and talk like a lawyer. The power of attorney is that document. So there we go. So you're granting the power to someone to do financial decisions for you. Well, what is that going to involve? Again, 30 years ago, it was a half page. Now it's 6 pages. And what were words on that 30 years ago half page, each word is now a paragraph. I mean, the post office has a paragraph. Social Security has a paragraph. The IRS has a paragraph. Your electronic passwords and electronic accounts are a paragraph. A lot of people have things in the cloud or on a online banking. So it's important to have that added on there. Then the power to make gifts is a very important part. If you're using the power of attorney document for your family member, parent, spouse, whoever, you're responsible for their money. And unless that has a paragraph that says that you have the power to make gifts, no more checks to the women's group at church. No more checks to grandchildren's birthday. Because legally, that's the money that's the person's, and you can't give it away to anybody. And I've had some ladies that were pretty upset when they found out that their church group wasn't going to get their $10 check every month. Well, you want, if that's, you trust the person to make those gifts, you can just say they have the power to make gifts to anyone. If you want to limit it, you can limit it. Most of the time you want to be able to do that also for possible Medicaid planning, because Medicaid, you may want to gift the farm to the kids to protect it, and that's a whole other topic next fall. That's a good one. You better get there. You can save the farm that one. Getting those, all these documents need to have 2 witnesses and a notary. The living will, the healthcare power of attorney, financial power of attorney. We used to be able to just notarize them or have 2 witnesses, but too many of the financial banks and institutions, they wanted a notary and 2 witnesses because they didn't want anybody to be able to fight about it. So the safest thing is when you're doing your will and you've got 2 witnesses and a notary for the will, you do them all. If you don't, you're still going to have to do that to do it right. You can't just handwrite a power of attorney on your own handwriting on a napkin. That's a will. We'll get into that in a minute, but that's not a power of attorney document. You have to have all the statutory language involved. Where do you keep it? Again, safety deposit box. Now, the financial power of attorney if you're going to deal with land, you have to have the original power of attorney document, the financial power of attorney, recorded at the county clerk's office. Because then when they do a title exam and they're saying who's signing the deed, it's recorded in there with the deeds. So if you think you're going to be doing any real estate, it's better to go ahead and record it. If you're not, you may not need to, but you've got to have that original to be recorded. Now, some of the others that you're not recording, the copy of a copy of a copy is fine. But if you're going to go a parent's going to have to go to the nursing home and be on Medicaid, and they're making you sell the land, that power of attorney has to say you have the power to sell land, and it has to be recorded. So that's an issue you have to address when you're creating those documents is, how am I going to use it? As to where do I keep it? You can always change any of the power of attorneys as long as you're competent and able. I had people ask, well, can moms change it at the nursing home or the hospital? What's the answer? Well, that depends. How competent is she? Will they let you in? I went down to Norton's it's a good thing it's Norton by the Cabela's there off of Gene Snyder. It's always good for a trip. I'm easy to go to that trip. But went down there the other day, and they were more than happy. This 55-year-old lady was in there and been there several times, and they wanted the documents because that would make their lives easier as the hospital administrators. So they were more than happy to snag another person to be witnesses for me. But now there's been times here, in the last couple of years, you don't get in a nursing home. The competency level of what does it take? As long as that person, if I'm doing it and it's any question at all, I want all the family to be in agreement. I prefer all the family to be there. They can't do that now at a hospital nursing home because you only have 2 people or 1 person. But they have to understand and agree. And if you've got an old document and you're just updating it, moving people up, well, that's pretty easy. They don't have a lot to complain about because 20 years ago, mom had the same thing. We're just fixing it a little better, tweaking it. But if it's a new set of documents, if we're going to have a fight in the family, we need to know about it ahead of time. Because if we do, we just need to go on into court and get guardianship. But most of the time it can be done. And if mom can come to the lawyer's office or dad, or I go to I travel all over the state because I like to see the land. I want to see the farm. I want to see what it looks like, where it is, because then when clients call, I've got an understanding of where that land is, what the value is, what the potential increase in value, how close it is to the interstate, things like that. Also, what the equipment looks like. I like to see that. Because sometimes some of the best equipment in the world, and some of those good old cows, come to find out most of the cows are on Social Security. I had one guy that the kids swore every cow had to be 20 years old. Maybe that's why they had 3 calves out of 20 cows. You can always make those changes if the company, you got to know who you are. You got to know that your family, in the sense of who's the objects of your bounty, they say in law school. And you got to have an idea basically of what you have. You don't need to know bizarre facts like who's the state representative in a certain district that's not yours or even is yours. That doesn't matter. You don't even really have to know what day it is. But if you know who you are, you know what you have and who you're dealing with, and it makes sense. And again, it has to make sense to me and to the other family, because, when you're naming the new caregiver that's been coming for the last 2 weeks, and you're cutting out your kids, that's a little questionable. That's why she brings her friend that's somewhere else, and he comes in to do those documents. Those are the only time really they get challenged. If somebody tries to create documents on their own, be careful with documents off the internet, because it can be a nice legal form, but there's questions that need to be made or decisions made. Do you know the magic words that make up those decisions, those legal phrases? And I've seen some pretty intelligent people really screw it up. And when they come back later and I looked at them, I'd say, "You sure this is what you wanted to do? Because what you just told me, this isn't going to make this work." And they get all tore up because they thought they had a plan. So make sure you understand what you're doing. Now, hospice is an exception. If you've got a parent or a spouse that hospice has been called in, they're excellent. They deal with it every day. They have excellent forms. They have up-to-date forms. I've seen lawyers that are some forms that aren't the best in the world and aren't updated, but hospice does a really good job with that. So something like that. Hospitals, when you're in a hospital, sometimes they used to hand out forms. I'm a little leery because sometimes, again, there's ramifications on the family side that they just want the right body to sign the papers. You want the right person to sign the papers, right? So be careful when you're changing these. So in estate planning, that's the disability. That first part was about disability. Not counting the 2-day seminar we're going to have about end-of-life issues, Medicaid, Medicare, trusts, long-term care insurance. But on estate planning, again, it's not just writing a will. But we're going to talk about, and the big part that you need to know is not, I need a will. Well, what if you don't have a will? How does that work? Maybe you don't. I have people call me and they'll say, "Well, I need to see about bringing mom in. She needs a will." Well, we get her in there and we find out she doesn't own any land. She doesn't own any vehicles. She hadn't driven in 10 years. She's got 3 bank accounts and she's got 1 child. Pretty simple to put that child on in survivorship, and then at her death, we just go to the bank and that counts the kids. But if you have multiple kids, now we've got a different story. You don't want to we're going to talk about using survivorship here in a minute. So estate administration is the process of the deceased person's assets. How do you get to them? How do you use them? How do you transfer them? You have to have papers with magic words on it. It has to be something that fits what you need. So there's several ways to do it. If you're intestacy, think about it, is testate means the last will and testament. Not any Old Testament, New Testament, but the last. The intestacy means without a will. So if you die without a will, or if you have joint tenancy with survivorship, like in a deed, a bank account, a CD, or will, or it might be in a living trust. We're going to just touch on a trust because that's another issue. Anyway, we've already talked about taxes, but that's part of the planning. Okay, the estate administration, every estate can be a little different. It depends on the people and the assets. And the steps that the process that you have to go through could be just a little different depending on what you have and how much is it worth and how many people you have involved. So you have to, the administration, the court legally, what they're looking for is, have you rounded up the assets, identified the creditors, identified the legal heirs, paid the bills, and then transferred the assets. If the kids want to fight about who got what ring, the court doesn't care. Because in our first seminar, we talked about all the children are exempt from inheritance tax. The court doesn't care. The court wants to make sure that every heir get notice, did every creditor get notice, and were the creditors paid? Well, first was the nursing or the funeral home paid. Funeral home has the strongest lobby. They have to be paid. The lawyers then have to be paid. We're behind the funeral home director. Taxes have to be paid. And sometimes there ain't enough money to pay everybody else, particularly credit cards, other debts. And then we have to take what money we have and allocate it out on a prorated basis for a percentage on the dollar, so everybody gets their fair share, whether they like it or not. So just because you don't have any money doesn't mean you don't need to go to court. Because if you don't, if you live with a home where mom was, you're gonna keep getting her mail that's gonna come after her to collect. And if you take those assets and do something with them, they're coming after you. So intestacy is without a will. You die without a will, you got to be the court-appointed administrator. So without a will, your hat says administrator. With the will, your hat says executor. If you're a trust, the trustee is on your hat. So just like whether you're a guardian, an attorney in fact, trustee, all these different legal hats, a lot of them are the very same duties. It's just what powers you have in the process to do it. And that's the complicated part. The other complicated part is what's in the probate estate. Well, if it's in survivorship, every once in a while I get one of the kids that gets hopping mad because there was that checking account mama had. Well, Junior, you ain't been around for 10 years and your sister has been taking care of mom for 20 years. And mom 20 years ago put her on a joint survivorship on that account. At her death, mom's death, daughter gets that account back. No process other than just like a husband and wife. You go up there, she's dead, I'll take it all out, I'm gonna move it somewhere else. Or you can just take a death certificate, take her name off. If you don't have the will, and it's in the probate estate, it's in their name. Without a will, half goes to the surviving spouse and half goes to the kids. Whose kids? Her kids, his kids, our kids? That gets to be pretty hairy. What if there is no surviving spouse? Is it we deal with brothers and sisters before it gets to the other part to the kids? Yeah. What if there's a parent alive in the nursing home on Medicaid, and now they get the money from the deceased child without a will? Guess who gets all that money? Medicaid. So then you got minors there to deal with. If you die and you have a minor child, who's the guardian of the child? Is there being a guardian appointed or a conservator appointed, like I talked about? Maybe this is the surviving biological parent. This could be somebody else, like a public administrator. Also, who's going to be appointed guardian? First one to the courthouse? Or, well, I should be it because I'm the oldest brother. Oh, I should be it because I'm the youngest sister and I don't have any kids. Well, I should get it because I'm retired and my kids are gone. But if you've got a will and you've named the guardian, you don't have your brothers and sisters, all of them meaning will and wanting to care for your family, but they end up stomping each other trying to help. And then the judge has to decide. So having that worked out is one other reason. If you haven't, once that child's born, I had a couple came in the other day that had a baby this month ago. And they realized they needed to do something because we had a lot of assets that were his and some of them were hers. When they got married, they're going to go different ways. Well, now we got a kid. It's going to go into this trust for this kid. But we got to name trustees and alternate trustees. Because what if grandma dies? This kid's at 2 months old. Grandma's 72. Doesn't mean grandma can't be appointed, but she needs the power to appoint an alternate. Joint tenancy, again, is a great way in a small estate or in an estate where one of the kids is operating the farm. At death, that bank account locks up. Well, if it's in joint tenancy of the survivorship, then the kid that's operating the farm can still access the money. It may still be dad's money, but I can get to it, pay the bills, keep mom's electricity on, keep the cows fed, the lease paid, taxes paid. Well, But if you put all your assets in survivorship with your kid, what if your kid gets divorced? What if your kid gets sued? What if they're in a wreck? What if they just take all your money and go to the boat and don't come back? Also, what if you put it in their name, thinking, well, if I die, the farm goes to the kid. Well, then now daddy's going to the nursing home, and Medicaid goes, oh, that's been within 5 years, and you give all that away, and the kid sold it when dad went to the nursing home and took the money. Medicaid isn't going to pay because that gift was within 5 years. So what I tell people is if you're over 60, you shouldn't buy, sell, trade, or give anything away unless you talk to a lawyer. Just ask, can I do this? Is this okay? Or what could happen if I do it? I know we talked about it, but I don't remember, but you said it'd be a mess. Is it worth a mess worth having or not? Because buying, selling, trading, or giving something away can cause a whole lot of trouble. Now, operating your business is the way you've been doing it, does it? Also, if you have your farm business in an LLC, the LLC, as it died, one of the members might have died or gone to the nursing home. That bank account is still open and running because that person, that's the entity, isn't dead or disabled. One of the members may be. So an LLC business entity might be a good choice for a family farm operation for that purpose. But you don't want to lose control, because if you give it to your kid, and I've seen this happen where they gave it to their kid, but the lawyer didn't put it in survivorship. They didn't have the magic word, joint interest with right of survivorship or in survivorship. They didn't state it. They just said they're giving half interest to the kid. Well, that means they're tenants in common, which is 50-50 owners. And if one of the owners dies without a will, who gets his half? Half goes to his spouse and his kids. So now mom and dad are partners with their daughter-in-law, which they don't really like. So be careful when you give that interest away. So, anybody, okay, need a will. In Kentucky, you could take the back of one of those pieces of paper that are handouts and date it, put your name, and say, I want this to be my last will. Here's where I want my assets to go, and sign it. And that paper is a will. But now you have your kid or whoever gets it would have to go to court and bring in 2 witnesses that swear that that's your signature, because you wasn't notarized, or if it was witnessed, you drag those witnesses in. If you don't have witnesses, you got to get somebody from the bank who's familiar with your signature. The tough part is when you got somebody that hadn't signed very many things, and that bank account signature card, that's one reason why they make you update them now every 5 years or so, because they would have somebody had to sign that signature card 30 years ago. Now they're 95 and can't, and they're doing this, they're writing like doctors and lawyers. And it didn't look anything like that pretty signature you used to have. I have some of my clients that will practice for days, signing their name before I come. And usually it's a woman and has a beautiful handwriting. It's like, you didn't even need to practice. You're better than 98% of the people I know. Okay, so the handwritten will works, but it means it's, again, just like I said at the beginning, it's part of a more complicated process. Having a lawyer prepared with 2 witnesses and a notary, the only person that has to come to court that was there at the time is nobody. The only person that has to be there is the person that's wanting to get sworn in as the executor that's named in the will. The lawyer that wrote it doesn't have to come. The notary, which is usually a lawyer, he's notarizing 2 witnesses' signatures, so they don't have to come. And the other person that signed it's dead. So that makes it just a whole lot easier. Now, the other difference is if you have a will or you don't have a will. If you don't have a will, you have to get a bond or insurance to ensure that the administrator is going to run off with all the money. Well, if you've got land, a house, and other property, that bond could be $2,000, $3,000, $4,000 a year. But if in one line of a goodwill, there's one line that I put in bold print that said no bond, no surety will be required on the bond of my personal representative, my executor. That one sentence could be worth $3,000 or $4,000, or at least $1,000. So if you do an estate plan that costs you $1,000, you're ahead by having that one sentence. Worst part is you pay $1,000 and you don't get that one sentence. Now you still might have to have a bond. So the magic words are important. The forms that you get, written forms, and you fill in the blanks, that doesn't work because it's mixing handwriting and printing. Now you can do it all in handwriting or all in printing, but you can't have both. You can go to LegalZoom.com or Mama Bear Legal Forms is another one. And you can get one, but you need to know the magic words, or you can screw yourself up real bad. That doesn't mean that doesn't work. If you have a simple estate, but I see a lot of simple estates that are really complicated, and it's usually because of the people, not the person that wrote it. So you get a lawyer, preferably one that does estate planning. Your tax lawyer may not do estate planning. Your divorce lawyer may not. Your real estate lawyer may not. I don't do divorce. I do taxes and real estate, but we do estate planning. So try to get somebody that does estate planning. Now, what are you going to do? What do you need to have in your will? I better open it. I got excited. I thought it was 7 o'clock. I'm getting paid one water bottle an hour. So I may have to go to 3 water bottles here. So what could you be in your will? A will, the simplest will I've ever written was 2 pages. The most complicated will I ever did was 37 pages. Now I've done trusts that are 60 pages long, but a will can be lots of things. So one, are you going to give away specific gifts? Do you have somebody that you got your grandfather's pocket knife that you want this son to have, or this daughter to have, or this grandkid to have? Or if you got 3 grandkids, you better have 3 pocket knives. Or if not, the executor needs to go buy a couple of them that all look alike and don't tell nobody. I've seen families fall out because the mom had 1 diamond ring and 2 daughters and a daughter-in-law. They wouldn't speak to each other for 5 years. And they'd gone shopping, vacation together. And the son, he said, why didn't I bring this up to you before? We could have gone and bought some rings and this had all been over. Specific gifts, though, can also be options. If you got one child that's farming, or maybe not with you, but nearby, and wants to operate your farm, to buy it. Well, fair isn't always equal, and equal isn't always fair. We talked about the first time. Well, what may be fair is to let the farming kid have the first option to buy it at an appraised price. And then the 2 kids, there's 3 kids total, the value of the land would be divided the 3 ways. Well, he doesn't have to bid against the world. He doesn't have to go to an auction, bid against every developer or doctor or lawyer, insurance agent, whoever. There's no fight. Get it appraised. Do you want it or do not? We have 45 days to say yes or no. We have 30 more days to get it closed, because the bank's going to have to get appraised. But if you inherit a third, you probably borrow money. But do you want to buy the farm at that appraised price? So it could be this child, and if he doesn't want it or she doesn't want it, the next child or next child. And that can be fair, and it's still equal. Sometimes I've had people say, I want this son to have, or daughter to have an option to buy at 80% of appraised price. they've been with me, helping me, doing all this stuff, I'm going to give them a little break. If it's in there, they can't argue about it. Also would say none of the kids want it. If you just say, I give it to this kid, what if he just turns around and sells it? Well, that defeats the point. You're wanting to keep it in the family. So what you might do is say, well, if none of the kids will want it, does any of the grandchildren over 21 want it? If they don't, let's sell it. If you have two that want it, they can bid against each other, but they don't have to bid against the world. You don't have to have the auctioneer, the advertising, the real estate agent, all that. So specific gifts can be really important. And I've had elaborate ones that had like 6 tracts of land. This tract goes to this kid first, and this one to this one. This tract goes to these other kids. Different kid had the first option on different tracts. So sometimes this tract is next door to this kid's house. I want him to have first shot. This one's next to this girl's house. I want her to have a shot. So that can be where fair comes in. We've done it with sometimes livestock equipment, but you need to make sure it's listed right. It needs to say detailed into farm equipment, tools, hand tools, power tools, inventory of supplies and feed. Because you have 10,000 bushels of corn in the bin, it could be different. That could be part of the estate, but the crop, the seed for next year, that could go to the kid farming. Gun collections, antique plates, different things. Had one lady that they said she had a collection of glass animals. I said, okay. I said, well, what do you want to do? And these kids were already fighting. I got been public administrator by the court. Once they did that, I know all of them. They were like, oh yeah, great. Keep them doing it. But they just didn't want this one brother to do it. He's only been in prison twice. The other had been once. Well, by the time I got appointed, everybody's fine. And but we said, what are we gonna do with these animals? I said, well, we could sell them on the internet. Maybe worth somebody in California more than somebody in Henry County. And they go, oh no, God, no. It'll flood the national market. The lady had 400 animals. It was probably more than these were really. I said, okay, we can't do that. I said, all right. We went through the house and divided up the property, the furniture and stuff. And I said, all right, the 3 girls, y'all divide this into 5 piles. And we're going to go load this furniture, your husband, boyfriend, and brother. We're going to go load furniture. And when we come back, we're going to draw numbers. And each of the 5 of you draws a number, and you get that pile of animals. And they go, oh. So we want to I don't know which pile I'm going to get. I can't load a pile. I said, no. So you need to put 3 squirrels in every pile and 2 rabbits in every pile. And if you want squirrels, you trade them, like baseball cards or something. Well, they had the great big, I left once that got done loading, and they said they went on for 4 or 5 hours swapping animals. Somebody went out and got pizza and some drinks, and they stayed the rest of the evening. So it depends on what you're dealing with. Yeah, no, that would have been a horrible thing to flood the national market with glass animals. Now, the boys only kept 1 or 2. The girls got a bunch. But those little rascals were worth like $20 a piece or more. Some of them were rare class squirrels. The beneficiaries, who is going to be the named beneficiaries? Is it a stepchild? Is it a not my child? It's my son's child, or not his child, but it's that other guy's child. So it's my step grandchild. Unless they're named in the will, stepchildren don't get anything. Now they don't pay inheritance tax, but they got to get it through the will. So when you have blended families, and nowadays, the generation above mine, my parents, they didn't get divorced. There were 6 kids in one family, 3 in the other, no divorces. 2 of them should have been, but they stayed together. In my generation, those two, my mom and my dad, there's 16 of us. Oh, we're past the national average. We got several on their second marriage. We've had all kinds of national or normal things happen. So, who are the beneficiaries? Is it a neighbor kid? Is it the church? Does church get it? And I've had a lot of people say, I'll give it to the church, but they can't spend it all. But I'll match 50% if they can collect the rest of it from the congregation. And then the living children get to approve it or disapprove it. So it's like ruling from the grave. But I can understand why you get a certain country church that gets $100,000 and the board gets spending happy because it's not their money. So I had one lady that she wanted her, she was in her 90s when she died, and she had really, what the family said, been a really good artist, but she got married when she was 18. She didn't produce a father. She wanted to get out of the house, or 16. She never had a chance to do anything with it. She wanted for that money to go to any of the grandchildren that had wanted to go to a camp or a school for their art. And if they didn't, she wanted her trustee to be able to do it for a kid through in the community. So every family might have something different. But with mixed families, beneficiaries are really important how they get there. You know, I've had where grandchildren, we had the children were 5 years apart and then 6 years more. So one kid's almost 10 or is 10 years from the other one, and one in the middle. Well, this one didn't have kids till he was 45 years old. Well, he's already 10 years younger than his sister, and she'd already had kids. So these kids are out of school, and these kids aren't even in school. And then this ones are in school, but they never went to class. So that grandparent set up, these kids got their money outright because they were already out of college, had jobs, they're doing good. They're adults, they know more about finances than everybody else in the family. They got theirs outright. These boys and girls, they need a little help. These over here, they're so young, we don't know. And if he dies and she remarries, now we're getting really nervous, Grandma. Because who's going to be in my house? Because he might get the farm. So the ages of these kids can just make all kinds of, I mean, there's all kinds of examples of why every family's beneficiary situation is special or unique. Is that what we're saying? No, politically correct. If we're going to name a guardian, children with disabilities, or like that one with art with gifts. You want to make sure maybe a kid goes to college, but you don't want this one to go to center and spend all the money, and the other one can't go to community college. Well, then we have to figure out how we're going to do that. Guardianship of a special needs child that's 50 years old and still living with mom or dad. Who's going to take care of them? You know, they may be able to live there, but not all really by themselves, and they can't manage their money. We need to take care of that. Trustees, all these things we could do with testamentary trusts. A testamentary trust is created in the last will and testament, not like a living trust. A testamentary trust can always be changed whenever the will is changed. But once the person dies, that trust can't be changed without going to court. Also, if it's a testamentary trust and a will, you have to report to the court every year about those assets, similar to the guardianship. Well, that may not be bad if you've got to report to the court. That gives you an out. If somebody isn't doing their job, the other family member can ask the judge to have them removed. Who is the executor? I will not ever name co-powers of attorney or co-executors. And everybody can say, well, my family, my kids, they all get along. And I'm telling you, in 30 years, every natural disaster that's created by will or trust or power of attorney had co in there somewhere. And I had one brother and sister. They're both one was a business owner and she was a nurse, very successful, both of them. They named them as co. Mama was in the nursing home. Dad died. The guardians are supposed to be co-guardians. You mentioned his mother's name. He dropped his head and wouldn't speak 30 minutes. So she had to do everything. But they're co, so they had both signed the checks. He just signed 20 checks and give them to her. Because he just could not handle his mama being in the nursing home. Now, Daddy dying and him being executor, he could handle that. But still, we had the same thing, is he's wanting to manage this and she's having to sign the check. So her schedule is bizarre, being a nurse. It would have been much easier if it had been one. Every fight I've ever had with a family that we've had to deal with, it's because there was co. And again, don't curse your family and say, all my kids will get along. Well, the way the estate is handled is the key. When most lawyers do an estate, and the way I do it, the way most do it, is the person that's the executor goes to court once, they sign the documents, but usually the first off every week or two, or then every month, and then every 3 months, everybody that's a beneficiary gets a big envelope of copies of everything. And if any decisions can be made, like the selling of property, everybody gets informed about it in writing beforehand. So there's not a decision that's really made outside and they're not hidden. It's just everybody's treated the same, except one gets to sign the documents. One has to go to court. And if that's the case, usually what happens, even in those fighting situations where the judge appoints me, if y'all want to fight, usually after about a month, 3 weeks, they don't even open the documents anymore. We send them a big stack of them. I'll see them somewhere and they'll ask a question. I said, well, did you read it? No. Because they're not worried about it. So the idea of codes, the reason why it's bad is the bank, the hospital, the creditor, the IRS, what if they don't agree? We got a tie 1-to-1. They definitely don't want 3. Because then you got 1, 1, and 1. So you've got to think about that a lot. And sometimes I've had families that, well, maybe these kids aren't it. Maybe I need to name my brother instead of my kids. Maybe I need to name my accountant or my lawyer or somebody else. Maybe it's my minister. They won't fight in front of the minister, I hope. The alternates, when you do a will, you're not doing it, well, if I die tomorrow, this is what I want to happen. Well, because what if you don't die for 5 weeks or a year or 5 years or 10 years? So the real point would be, when you do an estate plan, you have a window of planning. If you're 25 and you've got 2 babies, well, if you write that will, it's probably pretty good for what, 18 years until that oldest one gets to be 18. So you got near 20 years. So do it the best you can, do it well. And a lot of it may or may not change there. Well, it could if you inherit land from your grandmother or something. If somebody dies at your point. So as you get older though, that window becomes a 3 to 5, maybe 10 years. Depends on what happens. Once you get over 70, maybe it's a 3 to 5 year window. When you're over 80, it's about every other year we need to look at it. Doesn't mean you have to change it. We don't need to look at it. So don't think that I've got to figure out the perfect plan to set in stone right now. We want to have all, as things go, as time goes on this way, all the possible things are broad, but the probable things are closer, a smaller window. Plan for what's probably going to happen. Who could die? Well, if they could die, then who gets this? If that dies, then he dies, who gets that? So you need to have a couple of alternate situations that will take the effect of if something happens, I don't need to rush up and do the whole thing, because I've already got a built-in contingency plan for what if this person dies first. And the hardest time is people, when they die out of order, dang it. You know, and I've had, I don't know how many clients, two particular ladies told me, they said that having a spouse die is one thing, but having a child die is not right. They said, I don't care whether the kid was 60 and I'm 80, or they were 16. It just isn't right. But you got to plan for it, is what happens if that happens. So have alternate beneficiaries, have alternate guardians, have alternate trustees, have alternate executors. Because what you're buying is not a big binder full of paper. Estate planning, you're buying peace of mind that 6 months from now, a year from now, 5 years from now, when you got to use that plan, you can, I did the best I could for my family. In my situation and their situation, I did the best we could. And I've had several clients tell me that two older guys particularly said to basically the same thing. They said, you saved my life. And I said, well, how did I do that? He said, that binder. I said, what do you mean? He said, well, I was laying there in the hospital thinking about my wife and the kids and the farm, the boys and the girls that were off the farm, and my grandkids. He said, we had it covered. He said, the poor fool next to me didn't have a will, and that's all he did was yell and scream on the phone, telling his kids what he wanted. He said, I got home because I wasn't worried. So you're buying peace of mind. And that when you get done with the plan, you don't have to know all the legal magic words, but you need to know how to, it's like driving a truck. It's how do I start it? How do I steer it? And how do I stop it? I don't need to know how to fix the electronic ignition system or the tax code, but I need to know how that does and who I need to call if something happens. Because you want that peace of mind that it's doing what I want. I've had a client that had a great big old binder from a firm in Louisville, big tower, and I knew his farm. I baled hay on it. I helped him cut tobacco and knew his family. And he saw me one time in the cattleman meeting, and he said, he said, you're just starting out. He said, I'll let you look at my plan. Maybe you learn something. He was always teasing me. I said, yeah, I'd love to. Why don't you drop that off tomorrow? Well, sure enough, he did. He brings the binder in. He says, well, take a look there. You might learn something. Well, I read it over the next couple of days, and I called him. I said, what do you think's supposed to happen if this happens, if this person dies? And he told me, and I said, okay, that's kind of what I thought you'd say. He goes, why you ask? I said, that isn't what it says. And I named off about 3 situations. Guys knew his kids. Some of his boys had some problems. And I named a couple of situations. And my gosh, he was crying before he got off the phone. And he said, I've spent, $5,000 in this big binder. And I said, legally, this is wonderful written, but it doesn't fit your family, obviously. Can I come in tomorrow? Can I come in tomorrow? 8 o'clock, he's at my office. So he had just assumed that it fit what he wanted. And he told the lawyers something, and the lawyers wrote it, and he signed it. And it really didn't get into that discussion of what's going on with his family. So how much does the will cost? What's the answer? It's not by the page. It's like anything else. How complicated it is. Does it have that turbo testimony to trust in there or not? Is it a diesel or a gas? So a plan can usually, a good will plan that has all those documents is going to run probably for a single person somewhere between $750 and $3,000. Depends on how complicated it is. Depends on what you're doing. A couple, most lawyers, the second person in the couple, they charge about half what they did for the first one. It's not double. But it just does depend, because like I said, it's just having that child, having a special needs, having a trusted situation. where do you keep it? The original, lawyers don't, we can't keep them anymore because the lawyers used to keep them in their own little safe. And when daddy died, the kids had to come to the lawyer's office and get the will. Now, are they going to have the guts to grab it and run? Or are they going to let daddy's old attorney do it? Probably. So the Bar Association said, no, we can't keep them. So they need to be kept. You have to have the original will. Now, what if you can't find it? That happens. Well, if the lawyer is going to keep a copy, if they did a good job, you're going to have a binder somewhere that has a copy. Then you can have the originals, which you can't find. I had one poor lady, when her husband died, we talked about it. She was looking at it, holding it in her hand. A week later, when she came to my office, she couldn't find it. And her son had tore the house apart. But we had copies. Now we could go to the judge and the spouse who was to be appointed and any of the heir could all say, Judge, we can't find it, but we know this is it. And then they'd ask me, and I'd say, yes, Judge, this is, we may have to sign affidavits to say this was the last will that was prepared. We don't know of any other. We're all happy. Because it's like the professor used to have said, well, who's got the legal right to complain? Mom and the kids. So if they all agree, the court's going to be all right with it. Keep it in a fireproof box, a safety deposit box, somewhere where you're safe, a gun safe, a good gun safe now might be as good as anything. You can always change your will at any time. But when you change your will, don't start writing on the will. People will call me, I've written on the will, I'll just drop it by. I said, hurry. Because once you write just a line on the will, you destroy the whole thing. Because they legally assume that you meant to, also if it's torn, they assume you meant to tear it off. So if you're going to change it, what I tell people is get one of your copies and change the names on the copy. Don't touch the original until we do a new one. So you can always change it. More than likely, you should change it. Because over time, things change. When should I update it? Again, don't do it on your birthday. You'll just get depressed. Don't do it on New Year's Day. Groundhog Day is one of my favorites. Cold wintertime. But look at it regularly, and especially back to that, if you've been to the hospital, the funeral home, or the nursing home. It's probably somebody in your family that you went to see may be named in your will. A living trust is, we're talking about trust later, but it is, for some people, they call it a will substitute, but really what it is, they'll have a will that says, I give everything to my trust. Well, the trust can own it. So if they're done correctly, everything would be transferred to this trust. But this used to be a great Medicaid planning tool. That's all been changed. I used to write a lot of them just for Medicaid planning because they only went after the probate estate, what was in your name. Now they'll go after any trust you're a part of. How do you plan? This is really cool when it all comes in one at a time. It usually comes in with a little screeching car tires. It's like, stop right now. Get something, call, get started. Maybe you don't do this big trust or whatever, but get the living will, the healthcare power of attorney, get that done first. Then work on the other part. Because then if you become disabled, we can still deal with the rest of it. Get started, get some professional help. I'm not saying anybody needs it other than legal, but get somebody that understands your situation a little bit as far as your business. If you're a veteran and you're doing planning, there's a lot of VA stuff for disability planning that's very particular to VA. So you need a lawyer that understands those differences. Some great helpful things are available through VA for surviving spouse, for nursing home care, things like that, that if a lot of lawyers don't know about, I've seen to find. Without a plan, you get what comes. With a plan, you may get what you want. What does that song say? You can always get what you want. So do we have any questions from on the computer?
We do. Let me go back to one. Let's see here. Well, I'll go to this one first. How do you go about finding a good estate planning lawyer? Should you interview a few? Do you have to have a lawyer that practices in the county that you reside in?
Dartboard, phone book, no. No, they don't, they need to be in the state of Kentucky. If your residence is in the state of Kentucky. If you own property in Ohio or Indiana or Florida, you've got to deal with them possibly with an out-of-state lawyer. Interviews means you want. You're hiring somebody for a job. It's up to what you have. Get some references. Do you have friends that know somebody and they felt comfortable with, or they thought they did a good job with their parent or their neighbor? Main thing too is always ask the lawyer how much it costs. Now, if they're smart, they're going to say, well, it depends. We're a prize winner back there. What does he get? A bottle of water or a cup over there? But lawyers tend to, they want to talk about everything, and you'll walk out the door and you'll go, well, crap, how much is this going to cost? You need to ask. Make sure you ask. But they shouldn't give you an answer until they've gotten this information. As you can see, it's very dependent upon what you're doing. So it should maybe be a range. Do you pay by the hour? My clients are not going to pay by the hour because they don't care how fast I work. I will never work fast enough. Or they just flat won't call and they'll screw it up. And it'll cost 3 times as much to fix it. So I like it when my clients are in the combine or on a tractor or in a truck, and they say, call, and they either they get me or I call them back, and they say, I was just thinking about, should I get an LLC for this? I'm going to buy a bulldozer. Well, I don't charge by the hour, and I'd sure rather have somebody call and ask, and I'll say, well, it depends. But probably if you're going to get by a bulldozer and a heavy truck drive down the road, you probably need an LLC for liability purposes, as far as also estate planning purposes. I have a lot of clients that have their land is owned in a trust or an LLC that's owned by the trust. The operating business is another LLC. And then there's one is a trucking company, another one has a trucking company, a irrigation digging, well digging company, irrigation parts selling, and then also they do fly drones over your crops for you. So each one's different. Then there's land, there's partnership with the mother and the father is one. The boys have their own partnership, and mom, dad, and the boys have another LLC. So it depends on what you're doing, how much you're doing it. Another big question we're going to get in is it next time leases. I'm going to lease the farm. I get a lot of those calls. So-and-so's called me and has offered to pay me money to lease the farm. I want them to call me and before they say yes and go take a check. So we're going to get into farm leases, and that's part of it's going to be about hunting leases as well as cattle crops or whatever. But the idea of by the hour, usually I do it as more like by the job, just like building a house. In estate planning, what I like to look at is you spend all this time. And I mean, when I'll send out a worksheet, you send it back, it has health, family, and assets, and farm information. I call you back, see what we're looking at, set an appointment, and hey, you need to bring this and this, and think about this and this, so we can maybe get something. That first meeting is probably going to take 2 or 3 hours, either at my office or at the farm. If the farm, it could be a lot longer. It depends on how well your wife cooks or where we go eat. I can eat for a while, you can tell. But once we do build this plan, down the road, as things change, like this family, this young couple at farms, they had this baby. So I told her, well, we built the house. Now we're adding on a big room with this baby. You know, we're adding on, and then sometimes we're just renovating by changing some names. But if I've got that file and one of y'all call, I pull the file out and say, well, you still got this, this, and this. Yeah, I got it. Did you bought anything else? Yeah, I bought this and this. Okay, how's that gonna work? Well, if I've already got a lot of that information, it's a lot shorter call and a lot better call. So hopefully if you get the lawyer that you can establish this relationship with, that can work with your farm business, your farm family, and these things. What's the next question?
Okay, so we have one here from the first session. It says, if a couple has no kids and one spouse dies, does a surviving spouse have to pay estate tax? If so, how quickly do those taxes have to be paid?
Well, it depends. All right, we're falling asleep. They haven't fallen, I swear people on Zoom, they didn't fall asleep yet. Is they were just thinking real hard. They're thinking, are you talking about inheritance tax or estate tax? Surviving spouse is exempt from Kentucky inheritance tax, so no inheritance tax. Federal estate tax, they've got a $12 million plus exemption. Is the estate over $12 million? His half? Well, probably not. So the answer would be there's no taxes due. What's the big question? What's the big game we're going to play? Capital gains tax. Spouse dies, we need to figure out what we're going to do going forward to save on capital gains tax. So is that it?
Yes, that's
I think that covered that one, didn't it?
Yes, it did. That's the only questions we have right now. If anyone does want to come off of mute, they're more than welcome to right now.
Y'all got any? Y'all got any? I answered them all. Man, I'm reading minds, or they're swirling in there so fast you can't get them out.
We're just gonna wait until next time.
Yeah, well, most people, they say when they come to the office or come to the meetings, they say, you know, I enjoyed it, but dang, my head hurts. And usually when that person's getting ready to fall asleep, and then I'll say something, and they'll get the deer in the headlights look, and they'll be, I know they're thinking, holy crap, he knows my family.
Yeah.
Okay, so next time, 2 weeks, leases?
Yep, transition.
Oh, transition family farm leases in the fall, right? Okay, so next time is how do we think about specifically getting the transition of the family farm, meaning how do we get it ready to be transferred? Either while I'm alive, before I'm alive, or even getting it ready for when I die. How do I eliminate some of the mess? Or how did I deal with some of the problems while I'm alive? Because I've seen some 70-year-old children just shut up and quit fighting around when 95-year-old mom comes back out of the bathroom into my office. When she went in the door, they started fighting and fussing. But when she comes back out, they get real quiet. And they had one guy, he said, now I want you to explain to these kids what we're doing. I said, oh, wait a minute. That's why we're doing this while you're alive. So if you're dead, I'll have to do it. You're going to do it while you're alive. And he said, well, I'm going to sit over by you because they get too upset. I want you to cut them off. Okay, so transition to family farm. Are you putting this one up on YouTube?
Yes, yeah, we recorded it this evening, so we will put it up on YouTube. Philip's going to do that. And then he'll get me the link to it and I will email it out to everyone. Everyone that's watching virtually and there in person. I did email out the presentation, the slides from tonight. All the agents in the District 1 area does have them. So you can reach out to your agent, or if you want to reach out to me, that's fine too. And I can send you the slides from tonight. We do not have any slides yet from last week or the last session with Clint Quarles yet, but as soon as I get those, I'll get those sent out to folks as well. So
is this where I'm supposed to say, hit the like button and subscribe? And
yes, like, subscribe to the UK Plant Professionals YouTube page. I'm sure they'll like that little plug. But yeah, other than that, if you all have questions that you think of in the meantime until our next session, which is February 24th, jot them down, let your agent know, email me, whatever you want to do. That way we can ask Keith on February the 24th. So we greatly appreciate everyone being on this evening and taking the time out of your busy schedules. I know it's a lot of great information. As I've told y'all before, we've had to learn the hard way through a lot of this stuff with my father-in-law and my mama when they passed. So it's important stuff, and I know it's difficult to comprehend it all and take it all in, but it's great stuff, and we appreciate you, Keith, for helping us navigate all this and getting at least a baseline for folks to be thinking of for the future. So until next time, we will see you all on February 24th. Everyone have a great evening and take care.
Thank you.